When life gets complicated and probate feels overwhelming, there's a clear path forward. Welcome to Clear Probate, where we cut through the confusion and guide you every step of the way.
Welcome back to Clear Probate, where we make Florida probate and estate planning easy to understand. Today we're diving into a question that comes up all the time. What's the difference between summary administration and formal administration in Florida probate? If you're an executor, heir, or family member, understanding this difference is crucial because it directly impacts how long probate takes, how much it costs, and how complicated the process will be. By the end of this video, you'll know when each type of probate applies, how the steps differ between summary and formal, the advantages and disadvantages of both, and how to figure out which process may apply in your situation. Let's start with the basics. What is probate in Florida? Probate is the legal process for settling a person's estate after they pass away. That means gathering their assets, paying any outstanding debts, and distributing what's left to the rightful heirs. In Florida, probate can be handled in two primary ways: summary administration or formal administration. Both are court-supervised, but they differ in complexity, time, and requirements. Think of summary administration as the fast-track version of probate, while formal administration is the more detailed, traditional process. Each has its place, depending on the estate. Overview of summary administration. Let's start with summary administration. Summary administration is designed for smaller or older estates. Under Florida law, an estate qualifies for summary administration if the value of the estate subject to probate is $75,000 or less, not counting exempt property like a homestead, or the person has been deceased for more than 2 years, regardless of the estate's value. This process is generally faster and less expensive because it skips some of the steps required in formal administration. Steps in summary administration. A petition is filed with the probate court, usually by an heir or beneficiary. The petition includes information about the deceased, the assets, and the beneficiaries. Creditors can still file claims, but if more than 2 years have passed since the death, all creditor claims are automatically barred under Florida law. Once the judge approves, the assets are distributed directly to the heirs or beneficiaries. Let's talk about the timeline and costs. Summary administration can sometimes be completed in just a few weeks or a few months, depending on the court's schedule. Costs are typically lower because attorney's fees and court costs are less than in formal administration. For example, let's imagine John passed away in Orlando, leaving behind a car worth $10,000 and a small bank account of $20,000. His daughter is the only heir. In this case, because the estate is under $75,000, the daughter can use summary administration to quickly transfer the assets into her name without going through the longer formal process. Overview of formal administration. Now let's look at formal administration. Formal administration is the standard form of probate in Florida. It is required when the estate exceeds $75,000 in value, when there are disputes, or when the court deems summary administration inappropriate. Steps in formal administration. A petition is filed to open probate. The court formally appoints a personal representative, also known as an executor, to manage the estate. The personal representative is given letters of administration, which grant them legal authority to handle the deceased's assets. The personal representative must inventory the estate, notify creditors, and pay valid debts. Once debts and expenses are settled, the personal representative distributes the remaining assets to the heirs. Finally, the court reviews the process, approves the accounting, and closes the estate. Formal administration usually takes longer, anywhere from 6 months to over a year. Costs are also higher because of the additional steps, court involvement, and attorney's fees. For example, consider Sarah, who passed away in Miami, leaving behind a home worth $350,000, investment accounts, and several debts. Her 2 children are heirs, but one disagrees about how the assets should be distributed. Because the estate is over $75,000 and disputes are involved, formal administration is required. Key differences between summary and formal administration. Now that we've covered both, let's highlight the key differences. Value of the estate summary, $75,000 or less, or deceased for more than 2 years. Formal, more than $75,000 or complex estate issues. Court involvement summary, limited court oversight. Formal, full court supervision with personal representative appointed. Timeline summary, weeks to a few months. Formal, 6 months to over a year. Costs, summary, generally lower fees and expenses. Formal, higher costs due to extended process and attorney fees. Appointment of personal representative. Summary, no personal representative is appointed. Formal, a personal representative is appointed and given authority. Creditor claims. Summary, claims are only a concern if less than 2 years have passed since death. Formal, all creditors are notified and must be paid before distribution. Common questions. Families ask, what if the estate is just barely over $75,000? If the estate is even slightly above $75,000, it does not qualify for summary administration unless more than 2 years have passed. Formal administration will be required. Can real estate go through summary administration? Yes, real estate can be included, as long as the total estate value is under the limit, or more than 2 years have passed. But if the property has a mortgage or complex ownership issues, formal administration may still be necessary. Do I always need an attorney for probate? In Florida, most probate cases require an attorney, especially for formal administration. For summary administration, some families proceed without one, but legal guidance is usually recommended to avoid mistakes. What happens if creditors show up in summary administration? If less than 2 years have passed since death, creditors can file claims. Beneficiaries may become responsible for paying valid debts from the estate assets they receive. Practical tips for executors and heirs. Gather all financial records and property titles before deciding which type of probate applies. Check if the estate qualifies for summary administration. It can save significant time and money. Communicate with family members early. Disputes can push an estate into formal administration even if it technically qualifies for summary. Don't ignore creditor claims. Handling debts correctly is essential to closing the estate without legal issues later. When in doubt, consult with an experienced Florida probate attorney. Let's look at 2 real-world inspired scenarios. Case 1, Michael passed away in Tampa with just $40,000 in assets and no debts. His wife used summary administration and had the process completed within 8 weeks. She was able to cover funeral expenses quickly and transfer the bank account without complications. Case 2, Linda passed away in Fort Lauderdale with an estate worth $600,000, including investment accounts and rental property. Her children disagreed on how the rental property should be handled. Formal administration was necessary. The process took nearly a year, but ultimately the court ensured debts were paid and assets distributed fairly. These stories show why understanding the distinction between summary and formal administration matters so much. Now you know the key differences between summary administration and formal administration in Florida probate. One offers a faster, simplified process for smaller or older estates, while the other provides full oversight for larger or more complex cases. If this video helped you, subscribe to Clear Probate and let us know your thoughts in the comments. We read everyone. Here's a question for you. If you were handling a loved one's estate, which would you prefer? The speed of summary administration or the detailed oversight of formal administration? Share your thoughts below, and we may cover your question in a future video.
If this helped bring clarity to your situation, hit that like button and subscribe for more guidance.